but of singular importance. Is the fact that your brother issued conservatory orders for the maintenance of status quo. Effectively holding the sale of a 15% stake by the Kenyan government in Safaricom. Your Lordships, given the fact that this matter is of grave public interest, we are aware that numerous parties and applications will have been put forward, and we intend to fully cooperate with the court for efficient conduct of this case. I will be asking Advocate Anfang to shortly list some of the applications. Our proposal, Your Lordships, is that all these applications and other applications desired to be filed, and that this happens within the next 7 days because of the importance of this matter. And we welcome the inclusion of the Council in Nigeria on behalf of Governor Sonko. And all the replies, Your Lordships, no, we have no objections to the two applications. We propose that all the interlocutory applications will also be filed within 7 days. Same with any supplementary affidavits, if any, also within 7 days of service. And we will be willing, able to return to court on a day's convenience for ruling and final orders. In the intervening period, Your Lordships, I have 2 applications to make orally. Number 1, Your Lordships, is under Rule 5. D2 and E of the Constitution of Kenya, protection of rights and fundamental rights, fundamental freedoms, practice and procedure rules. Chunga rules, absolutely. Yes, we used to talk of Chunga rules. Yes. 2013. We wish to join Vodafone Kenya Limited as the 8th respondent. Kenya Limited. We will be proving, Your Lordships, Vodacom Kenya Limited is 18, Your Lordships, of the Mutunda rules, we pray for leave to amend the petition dated the 26th of January 2026 to be able to address a few issues and indeed make the petition cleaner. January 26th this year. And in the meantime, Your Lordships, we finally pray for extension of conservatory orders issued by your brother Justice Lawrence Mugambi on the 23rd March 2026. I beg your pardon? On the 23rd March. Yes, this year. Your Lordships, this is informed by the fact that the first respondent has approval in their hands from the National Assembly effective from 1st of April 2026, never mind it was on Fool's Day, but they have the approval. They have the approval to sell the subject matter of this petition. i.e. 15% shares of Safaricom. It's important, Your Lordship, to mention that approval was in violation, express violation of the conservatory orders issued by your brother, Justice Mugambi. And the reason why we strongly argue for extension of the conservatory orders is also because even when the court was in vacation, the landlord, the Attorney General, attempted to move court to have the conservatory orders lifted. That goes to show, Your Lordships, despite faith on the part of some of the respondents in a matter as crucial
if counsel is suggesting that the Attorney General attempted to move court, perhaps he should identify the application. There is no such application. It would be helpful for us to respond to a specific factual assertion. Otherwise, for the court to say that is unfair, the Honorable Attorney General and to the response.
I take the motion of
Council to just maybe the record shows the final summons application and the recess rules.
Thank you.
Is it all your right?
Indeed, and the matter was brought before you. So I'm not attempting to read at the level of my senior brother, Ohanga. It would be a terrific mistake on our part to attempt to mislead court. That's the application of authority.
Please, 27th of March 2026, the application was seeking the application had during the application period and issued the action. I don't think there's anything wrong because we are just following the due process. And the actions were issued to that effect, and there's sort of compliance with the application worship. So that's the second issue. Yeah, I think I read with that application and gave directions. And let's leave it at that.
Yeah. Thank you, my Lord.
Yes.
We stand guided. But the point I was making was if the conservatory orders are not extended, because under Justice Mugambi's ruling, your lordships are at liberty to vary those orders, to give whatever directions you may deem necessary in the interest of justice. And my lords, the country is watching, because Safaricom happens to be literally the goose that lays the golden egg, contributing significantly to the GDP of our economy, in excess of 8%, in other words. The world has actually taken note, and I think that's why the interest in other players in that space. Because the name M-Pesa, my lords, M-Pesa, it's over Kenyan innovation and invention, has hit international market space in terms of inclusion by citizens who otherwise would have no business at all going to a bank. That is a price you not use. Evidence even is available, artificial intelligence shows that every minute Kenyans transact approximately 15 million shares on M-Pesa alone. Therefore, we strongly urge that the lordships favor the petitioners with the extension of these conservatory orders until the matters which are heavy are deliberated between the lordships and brought to a conclusion that will look and sound fair and just to the Kenyan people. My final comment, Your Lordships, is if these orders are lifted, the rest of the time before Your Lordships will be nothing but academic exercise, and it will serve as a huge disappointment to Kenyans who have been following this matter so keenly. And this includes, my lords, the mama bogas who are able to take their product to the Kulima market and pay by M-Pesa, the more than 171,000 dealers, the lordships, Safaricom employs committed payments. So he asked the bank to deal with the matter of the applications, and we want to urge that the Lordship consider extension of these conservative orders, and so that we can then come before you when we have adequacy of time, and when we come to the position to listen to the deeper arguments, including the undervaluation of the shares that are allegedly to be sold to a foreign entity. I repeat, my lords, to a foreign entity. As we approach the election year, it is not lost on anyone that Safaricom serves as a major platform for delivery of essential data. So this falling in foreign hands by lordships will compromise the security not just of our sovereignty, but our security. I beg to move. Compromise our national sovereignty and security, because, my lord, Safaricom is a national security asset.
My lord, my ladies, thank you very much for this. Mr. Lepar for the petitioners. Yes. Yeah, on behalf of the petitioners, Mr. Ilongo Nyakera filed an application dated the 3rd day of January 2026 seeking jointer or seeking to be joined as an interested party in this matter, and because of his vast experience in financial and economic matters, we will not be proposing. It's actually coming to coordinate this particular petition. The Lord, as my landed senior counsel, Honorable Kalonzo has said, Safaricom Limited Company is Iran Republic. So therefore, what they are saying, my lord, my ladies, is that they do not want to see the control of this particular strategic national asset to foreigners, where the headquarters of this particular company are in Nairobi. The Lord, before even I proceed further, there are petitioners, because this is the lead petition, and I have not even heard, I don't think you took the quorum of them. Because this our petition, each one is the lead petition, but I think there are 2 more petitions.
I thought Ms. Kalonzo introduced all the petitions.
Yeah.
Those petitioners are appearing in persons.
They are appearing in person.
Yes.
Yeah, we'll come back to that.
Yes.
We'll go to our question.
Yes.
But it will be comfortable if you give us information in addition
Yes.
to what has been submitted by seniors.
Yes.
Rather than repeating.
Yes, my lord. So therefore, we are saying that as early as, I think, the 13th day of this month, the Attorney General also filed another affidavit actually saying that he got approval from Parliament, which actually consolidate our fears in the petition that Parliament is being coerced by the Attorney General, by the Ministry of Finance, or by the Treasury, to see its Article 95 and 94 responsibility of oversight. It's a clear indication. My Lord, every party, including Ajawara, who actually says that they will be struck out from this particular petition, will be highlighting their own application, which we have proposed, and we have written submissions to that effect, but we await directions from this court. You know, with, on top of what my senior counsel, Honorable Kalonzo has said, we'll also be seeking direction whether the law firm of Andrew Mukite Musangi can represent Safaricom, Safaricom being regulated by the regulator, because Mr. Musangi, as we do know, is the chairman of the board of directors of Central Bank Kenya, which is a regulator to Safaricom. My Lord, we'll also be seeking direction as to whether the law firm of OK, Central Bank Board of Directors, and therefore there is a clear conflict of interest on Mr. Musangi's side, because he's a public officer, having been appointed by President Ruto in 2023, I don't remember the exact date, but he is the chairman of the board of directors Central. Unless he sits that position here, for him to continue, we'll be very happy for the president to appoint another chairman of the Central Bank board of directors, for him to continue being this matter. Your Honor, we also, my lords, my lady, we'll also be seeking directions as to whether OK can represent the Attorney General, going by the recent pronouncement by Justice Mochi Nakuru, that the Attorney General cannot be heard to say that the able state councils they have in the office of the Attorney General can go ahead and procure private law advocates to represent him, and more so in a public interest litigation. Because this is a pure public interest litigation. My learned colleague has said that it joins the most marginalized communities in the digital economy. Every village, including my own village, and even Saikuru, where there are so many M-Pesa shops there, meaning that the people there, Mamamboga, as we call them, I try as much as possible to avoid that terminology, is connected to digital economy via Safaricom. And therefore, my learned colleague very eloquently said that we do not, or the petitioners do not want to cede. They do not cede any more shares to foreigners. In those few words, my lords, my ladies, I invite my learned colleague, Mr. Jiro, very briefly.
My Lord, I want to associate myself with the submissions made by my learned senior counsel and my learned friend, Mr. Lempa. And just to begin by commenting your Lordship, that the reason why we are seeking clarification of the participation of the firms is on the basis that Justice Mohoshi gave a rider that unless there is a formal approval by the Attorney General, this morning your Lordship has gone on record that we have a counsel originating from the office of the Attorney General representing that party. To the best of my knowledge, your Lordships, that approval has not been shared to the parties and all brought before this court. nor did the council have the obligation of disclosing to the court of the existence of that particular approval. Those are orders of your brother are still in force, Your Lordship, my lady, and they cannot be wished away. Number two, Your Lordship, is a question that was raised of the sovereignty. Safaricom sale must be viewed in the context of the sovereignty of the people and the question of territorial integrity. Why do I say so, Your Lordship? It's because if you go to section 44 of the Election Act, the Election Act has provided a provision for integration of system. The IEBC system, they call it electoral integration system, with Safaricom being the primary data host and being the primary conveyor belt of the data emanating from IBC to Safaricom.
Lordship, if I may, with your permission. Yes. Apologies for cutting my colleague short. Lordship, there is a court of appeal authority that says that parties are bound by agreements. There is no mention of election-related issue in all the three petitions. If they so wish to include what they are submitting on, they have an application for amendment of the petition, which has been let ordered. So that, Your Lordship, we also must get an opportunity to respond to those issues relating to election. That is their issues. They must restrict themselves to what they filed and what is before this court, so that all of us can respond. So those are issues of elections, are issues of evidence from the bar. There is no affidavit that has been filed on the record. And related to what they are submitting on. That's fine, Your Lordship, but it is not in our fact. That's fine, Your Lordship, but it is not in the I stand guided.
My Lord, I think where counsel is straying from the document is to now say they have to use Safaricom. The law says you will use an integrated electronic data system, period. It does not say you will use Safaricom. So stick to the law.
Stop at
and
what
don't.
the law says.
Yes.
I will stop at that.
You
I
need
will
to
stop
draw
at
the
that.
line.
In fact, I've ordered a comment about section 4.
I will stop at that.
Stop at that.
The court will do the inference.
Yes. Continue.
So, Your Lordship, and having, of course, made the justification for the application of leave to amend the petition, Your Lordship, I want to go to the next limb on why the orders of justice, your brother Justice Mugambi, ought to be extended.
In addition to what senior counsel submitted.
Yes, Your Lordship.
Is not repeated.
In addition to that, Your Lordship, the question of public interest in this particular proceedings is of paramount importance. That this is not a dispute between a buyer and a seller. It's not a dispute. It's not a per se commercial dispute that is before you. It's a dispute that goes to the root of the sovereignty of the data contained by the or held by Safaricom, the security of that data, and the importance of knowing how that data shall be regulated and by who shall be the custodian of that particular data. As indicated, Your Lordship, the 30 million or over 30 million subscribers to Safaricom are before you this morning. And they are before you this morning pursuant to 40 million, I'm corrected, by pursuant to Article 22 as read together with the Article 258 of the Constitution. So the persons before Your Lordship is not Tony Gashoka. It's all of us who subscribe to Safaricom. That alone, as read together with the Supreme Court decision in the case of Peter Katirao Munya, the question of public interest demands that the court just extend the orders as granted. Additionally to that, Your Lordship, the case of Dimar Florian versus Director of Migration, which is petition number E074 of 2022, justifies the extension of these orders. And in this case, the court was looking at the question of public interest again. What inconvenience, what prejudice will the members of the public suffer if the sale of Safaricom is to be okayed, if the orders are to be lifted? I'm sure the respondents will argue that the sale of Safaricom is going to generate public resource which might be plowed back to the public. But there are competing interests here. That I, Ndegwa, am a subscriber of Safaricom as a private subscriber representing 40 million of others, versus the interest the government is indicating that they want to raise resources, they want to raise finances. These competing interests, Your Lordship, must be balanced in favor of the parties who stand to suffer more, who are the subscribers. Why so, Your Lordship, as I pen off? It's because this is not the only means which the government can deploy to generate resources. While I endeavor the subscriber of Safaricom is the only platform that I can participate in the data technology and the digital economy. That is the only platform. That competing interest, Your Lordship, the balance tilts in favor of the persons that Tony Gashoka represents this morning. As a question of the amendments to include the 8th respondents as proposed, Your Lordship, again, there is no inconvenience that will be suffered or prejudice if Vodafone Kenya is made a party to these proceedings. In matter of fact, Your Lordship, under Mutunga rules, as indicated and quoted correctly by a senior counsel, is that the inclusion of the respondents will have the effect of completing the pleadings, in the sense that, Your Lordship, that Vodafone is proposed to be the ultimate beneficiary of the sale, while knowing that they are currently shareholders of the existing Safaricom. At the fullness of time, the question of the insider trading will be before Your Lordship, and whether it can arise at the fullness of time as and when the amendments is granted. I rest my case.
So those petitioners who are in person, before we come to you, welcome to the respondents. Petitioners who are in person,
Your Honor, I'm ready.
are you a petitioner?
Yes, right of honor. Petition number 2.
You are a petitioner?
Number 2.
In which case?
This case.
Are you represented? You know we don't want duplication. If you are only representation.
Your Honor, you've not had the mention that I represent.
Yes.
You talk about representing somebody else.
Yes.
You've not have the mention my name in the case.
It's actually cited. The citation.
Oh, in the citations? Yeah, we will add in there. That's okay, counsel. All right?
Yeah, so
Mr.
I will represent myself, Your Honor.
Oh, you're in person?
Yes.
Oh, you are not a legal counsel?
No, I'm not, but I represent myself. I'm capable.
Oh, you are capable?
No, that's not the case. That is not the question. The question is whether when he presented the petition, he was represented. And he is represented and he
Yeah,
still
this
is.
petition was filed through legal counsel. That does not mean that we cannot allow you to speak.
Yes,
But
that's,
with regard to this matter, right? With regard to this matter, unless there is something very new which has not been stated, we will not allow you to speak for that. Okay?
Yes, but I have
If there
something
is
new.
something which you think should be added,
Yes, Your
then
Honor,
we will allow
I
you
have
to
something
speak.
very
Or
little.
you can talk to one of the councils to raise it in reply. There is another time of reply. They will reply what you say here. So that opportunity is there. And you converse with them.
Your Honor, I have something to say which is new.
Which is new.
Yes.
Well, what is it before I even record it?
Remember, Your Honor, this petition is not just about Safaricom sale,
Yes.
but it's also connected to the proposed infrastructure bill, infrastructure fund.
Fine.
Yes. And given by the facts that have been stated in this matter, it is very clear that whatever they are trying to raise by selling Safaricom
Yes.
to collect to put infrastructure fund is so much a drop in the ocean that it cannot help the situation, because a government that has 13 trillion debt cannot sell something for around 200 billion to sort out that debt hole, because the argument was that the government is so indebted, so you are selling Safaricom to put the funds into infrastructure fund, and I know that the debt is so deep.
I'm sorry, my lord, but we have to rise again.
Yes.
This is a really misconceived proposition.
Let me direct it. That's why you see, I said I'm not the record.
I will wait for the direction.
Now what we do, I'm getting your argument, but it is an extension of what Nego was talking about. And in the reply, when that time comes, and you whisper to Nego, you have to just next to you. And then when we come back, Nego will tell us the way to proceed, so that we don't get confused. Just take your seat. Continue talking,
I continue talking.
No.
My lord, the matter is sorted. The matter is sorted. The petitioners are Tony Gachoka and my friend Ogola. It's as simple as that. So whatever we have said, we are representing. But as we amend the petition as well, given the opportunity, we'll also take into account what is talking.
Yeah, what he's talking about. That will be done. So during your time of reply, we had discussed. I was telling you, continue talking with the Table Zero, right?
Yes, Lordship.
Yeah,
I'm well guided.
Any other petitioner? Any other petitioner? All right, let me come to you, Ohanda. I know you also organized that there will be no repetition.
Yes, my lord, we will try not to repeat the points that we want to make. We will also try not to be sensational. We will try not to engage in rhetoric. My lord, let me start by saying that with respect to the applications for joining up, those will be opposed, and they can join the queue of applications.
So you oppose?
We will be opposing any application for joining up.
What are your reasons?
They do not meet the strictures set out by the Supreme Court itself with respect to the question of the joiner, interested parties, and what they add to the contest before the court. When the applications are served, and we have the opportunity to respond, as we must be given.
You are not being served? Anderson said we are served everybody.
When they're served, we will respond. It is part of the directions that my Lord will give.
Yeah, and I'm asking you to give me the reason why you think we should not allow them.
And I say, my Lord, I stated that the Supreme Court has given us the parameters which relate to the question of joinder of interested parties
Yes.
and what they add to the substratum of the contestation before the court. It is a respectful view which we will put forward more fully in our responses, that the applications for joinder do not meet those strictures. My Lord, it must be borne in mind that we are not now arguing the applications for joinder. We are merely expressing the fact that we will be opposing them. My Lord, the next point I wish to address is the questions regarding representation. Once again, when and if formal applications are brought, we will respond to those applications. It is not sufficient to rise and state from the bar that there are bases to object to the representation of a party. We're well aware, my Lord, that the decision of Mr. Justice Muhochi from Nakuru has been stayed by the Court of Appeal. And as Mr. Maro was trying to state to the court, this is the reason why pleadings are required, so they delineate the contest between the parties, and we can fully respond. It is unhelpful, my Lord, to bring issues of that nature when counsel rises without prior notice to the other parties. Let me come now, my Lord, to what is in fact in contest, which is the question of the status quo. Let me correct my learned friend, Senior Counsel Kalonzo Musyoka. My Lord, there are no conservatory orders issued by any court in this matter. And it is therefore misleading to premise any arguments before the court on the basis that the judge issued conservatory orders. The ruling, my Lord, of Mr. Justice Mugambi on the 23rd of March was very clear. The judge was pressed for time. He was aware that he had ordered that a bench of 3 be impaneled, and that this was going to await the directions of the Honorable the Chief Justice. And therefore, not to embarrass the bench, he directed that the status quo be maintained until the empanelment of the bench. So far as we are concerned, therefore, the orders of status quo expire today, and they can only be renewed if this court determines that there is a proper basis to renew those orders. But my lords, your ladyships must bear in mind certain things. But first and foremost, is that orders of status quo cannot supplant conservatory orders. They are not a replacement for conservatory orders. There is therefore before court a formal application for conservatory orders. That has been responded to. And submissions have been filed before the court. It bears stating, Lord, that that application for conservatory orders was brought under certificate of urgency at the time when the petition was filed. The certificate of urgency is dated the 20th January 2026. And the notice of motion itself is dated the same date, 20th January 2026. At the time the judge before whom the matter was placed did not see fit to order any interim orders of any nature. And in our respectful submission, the directions that we will be looking to from this court relate to a date when arguments, full arguments, can be advanced on the application for conservatory orders. In fact, my lord, this court cannot issue any orders of any nature in the state of flux in which the petition presently is. You've been told various things. You've been asked for leave to amend the petition. We do not know the nature of those amendments. And you've been asked to join another party. In the result, my lord, you do not have a full case before you on which you can determine on a prima facie basis the merits or otherwise of the petition that is before you, because the case is still developing. Well, it has been suggested to you that there is a great public interest in this matter and that there are 40 million Kenyans who are in support of this petition. Although, so far as I'm aware, there are 8 petitioners before you. The petitioners should not flatter themselves. The submissions, my lord. Was my lord checking something?
I can see. The Jabril is still on. Judge, you can hear us?
I'm watching her as well, my lord,
Yeah,
as well as you, as well as Justice Mbuya. Yes.
Now she's back.
Yes.
All right.
Very much.
Okay. together.
Well, Lord, I was saying to you that the 8 petitioners should not flatter themselves and suggest. In fact, there are 4 petitioners, I beg your pardon, not 8. 4 petitioners. I even give them more credit than they deserve. Should not flatter themselves and suggest that they represent 40 million Kenyans. They do not. What we are being obliged to do now, my Lord, your Ladyships, is to put forward arguments relating to the application for conservatory orders in an application relating or in an assertion that the orders of status quo should be extended. So it obliges me to demonstrate why the orders of status quo should not be extended. First and foremost, Lord, as has been deposed in this further affidavit of the Cabinet Secretary for the National Treasury, on the 31st of March 2026, Parliament gave its approval to the sale of the government's 15% shares in Safaricom on the 31st of March. That approval, my lords, your ladyship, was given pursuant to Section 87A of the Public Finance Management Act. It has not been suggested, my lord, that Parliament acted illegally. Indeed, one of the prayers in the petition is that this sale should not be allowed to proceed without parliamentary approval or without the approval of the National Assembly. So one grievance expressed by the petitioners is immediately resolved. But it doesn't stop there, my lord. In granting its approval, Parliament undertook extensive public participation . And that is deposed in the further affidavit of the Cabinet Secretary. Parliament also imposed various conditions which must be complied with before any sale can be consummated. All this is in the affidavit, my lord, your ladyship. confident you will read when you retire or have read. Parliament, my lord, also considered the question of the valuation of the shares and was satisfied that the shares were being sold at a value that was appropriate in the circumstances. Parliament also required that the requisite regulatory approvals should be obtained. All this, Your Ladyship, in compliance with Section 87A of the Public Finance Management Act. So that, my lords, there is no lawless race to completion. It is a sale grounded in law that is complying and ticking every box as required by statute. The petitioners, my lord, suggest in the titling of the petition that the matter involves the Public Procurement and Disposal Act. Nothing could be further from the truth. The Public Procurement Act, my lord, itself states categorically that it does not apply to the sale of shares.
Your Lordship, without disrespect, is my learned senior not raising new issue that we did not touch in our application, especially
the face of the application.
Public procurement in respect to the extension of the orders. We never touched in it. We made prejudice in our response.
You never opportunity to reply. So let it proceed. Let those all that they say reply.
I'm on the leadership.
Yes, continue.
So that, my lord, the point I am making is that the petition itself proceeds on a flawed legal premise. Lord, the general policy of the law, as we understand it, is that the courts should, so far as possible, respect the principle of separation of powers. The statutory architecture gives the responsibility for the sale of government-linked assets to Parliament to approve and to design a pathway. unless it is shown that Parliament has acted illegally or in breach of the Constitution, the courts should be slow to interfere in that statutory architecture and to respect the principle of separation of powers. The question of economic policy and the application and use of public assets, Lord, is in the first instance a matter for the executive. Once again, unless it can be shown that the executive has acted illegally, the executive is subverting the economic circumstances of the people, or that the executive has not taken into account certain considerations, the courts should be slow to interfere. Lord, in the two affidavits sworn by the Cabinet Secretary, he has gone to extensive lengths to explain why it is necessary at this time or considered prudent to allow the disposition of 15% of the government's shareholding in Safaricom. Not to a foreign entity, my lord, to a Kenyan entity. Vodafone Kenya Limited. Oh, Your Ladyship, the arguments put forward by the petitioners
Oh, apart from this. Okay, that is expected. Continue, John.
yes, we get used to this from time to time.
Yes.
The arguments put forward by the petitioners to the effect that somehow it will affect their subscription or somehow it will prejudice Mama Boga suggests that Safaricom is being liquidated. This is about a sale of shares, not about the liquidation or winding up of a company. The company will continue in existence, will continue to offer world-class M-Pesa services, will continue to serve Mama Boga, and will continue with its mission, if called upon, to offer a technology platform for the elections. That will not change, and there is nothing on the record to suggest that the entry of a new party will somehow change the trajectory of what we'll all accept is a Kenyan icon. argument about sovereignty are weak at the very least. Safaricom's shareholding structure already includes foreign ownership. I am struggling to understand how the sale to another Kenyan company will somehow threaten national security, affect our sovereignty, and lead to a breach of our borders. Lord, this is purely speculative. What we have before this court, Lord, involves the sale of shares. This is the subject matter of this petition. These shares are listed securities. They are traded on the Nairobi Stock Exchange. They are not somehow going to be spirited off to the Isle of Man or to some far-flung place out of the reach of the court. In the fullness of time, and having had the petition, the court finds some illegality or some other reason to vitiate the sale, Article 23, my lord, your ladyships, gives the court wide remedial power. The court can fashion such remedies and reliefs as it considers appropriate in the circumstances. Lords, there's been a suggestion that somehow the sale of these shares will dissipate our intergenerational wealth. And I've struggled with an answer to this proposition. The Cabinet Secretary has deposed and deposed to the fact that Safaricom delivers a dividend of 7 billion shillings annually to the government. The sale, my lord, will result in approximately 204 billion shillings into the government coffers. If Safaricom continues to deliver a dividend of 7 billion shillings annually, the Cabinet Secretary has told us, and mathematics will tell us, it will take 30 years to realize the gain from this sale. Furthermore, the government will receive 40 billion shillings upfront as dividend. I will continue to retain a 20% ownership in the company. To what are these funds to be applied? The funds are to be applied towards various infrastructure requirements. Indeed, the expected inflows have already been factored into the current fiscal framework.
The judge is in there?
I beg your pardon, she seems to have
She's there, Your Lordship. That's the video is on.
Oh, okay.
It has been going on and off from time to time.
So Judge, can you confirm that you are still with us? Judge Aburini? Let's confirm. Can you confirm that you are still with us?
Yes.
Okay.
Yes, Honorable Presiding Judge.
Thank you. Let's continue.
Thank you very much, my lord. Thank you, your ladyship.
Yes.
So that, my lord, the amount in question, I was saying, has already been factored into the current fiscal framework. Which the National Treasury projects to use in implementing macroeconomic and fiscal policies, as well as managing the national public debt.
On a point of order,
Yes,
Your Lordship,
yes.
I really hate to interrupt my learned friend, Senior Counsel John Ohanga. But are you satisfied that he's not really now arguing the petition? He came before this court really
So
to try.
I was going to raise that question, whether now
Yeah.
there will be need to only the application, because what you have with John is really something.
Yes, my lord, because we have to bend over
The
backwards.
formal application.
My lord,
Here we are talking about the extension of political order.
yes, it is critical. It is critical because Senior Counsel suggested to you that the public interest swung in favor of maintaining the status quo. I am demonstrating, my lord,
Yes.
that the public interest, that issuing an order of status quo is inimical to the public interest.
Well, you should have started there. so
Yes.
that These others come as an example.
Very well.
And that's
Most
the
of
way
them.
you are proceeding.
Thank you very much, my lord.
You have in the application.
I'm guided. So, the point I'm making
Yes.
is that the order, any orders of status quo
Yes.
would be inimical to the public interest. Lord, the petitioner's public interest case is largely abstract. There has been mention of Mama Boga, there has been mention of M-Pesa, there has been mention of elections. But there has been nothing stated to displace this significant public interest in the application of these funds towards some of the infrastructure projects that are set out in the Cabinet Secretary's replying affidavits. Those, or that infrastructure, roads, airports, bridges, dams, those, my lord, constitute intergenerational assets. It cannot be said that one class of shares, if sold, will dissipate our intergenerational assets. We must think about this broadly and in a way which advances the needs of future generations.
Are you about to finish?
Yes, I'm about to finish. So that, my lords, the status quo, if maintained, would have to be very closely defined, because Parliament, the National Assembly, as I say, has given its approval. The approval is lawful under Section 87A, and it has set out a runway. And that, my lord, is the status quo. The status quo cannot be defined as equating a conservative one, because it then becomes final in effect. And it has the effect, Lord, of substantially determining the dispute, because there is a real threat that the proposed purchaser could walk away. The guidance given by the Court of Appeal, the Supreme Court in Munyak, requires that the public interest be taken into account, constitutional values, and proportionality. Such orders are not to be issued lightly. Now, respect the solution, it is this court's responsibility accept the approval by Parliament and to allow the progression of the transaction. Because there has been no demonstration that there is anything unlawful about this transaction. There are certain points another friend, Mr. Sandi, will be making. I will seek for us to be for time and patience.
Recently,
specifically, my Lord, I'm the non-executive chairman of the board of the central bank. Perhaps before the petitioners decide whether they want to formalize their statements into an application, they might want to consider the actual role. And also, the principles for conservatory orders have been canvassed extensively into simply public interest considerations, consideration of constitutional values, and last but not least, proportionality of issues. All of those are invested and they are well known to the courts. My Lords, let me focus on the last one. The first two have been extensively canvassed by my learned senior colleague. But in so doing, let me state that I have the benefit of a perspective of the fiscal impact of conservatory orders, given where I sit as the central bank. My Lord, let me put stark numbers on the table for the court to understand. My Lord, a transaction of 244 billion shillings is on the table. And my colleagues may sit and argue, as they have done, that there is a danger of dissipation of the subject matter. And in the same way, they argue that there is no loss from conservatory orders being issued. The following is the loss. My Lords, put 244 billion shillings conservatively in a money market investment at 10%. Every year, those funds will yield 24.4 billion. No, but the point I'm making is let me complete my point, my Lord.
It is very, I would really to the senior counsel. But is that information in an affidavit? And secondly, he admits that he is part and parcel of this particular transaction, and therefore he should be an expert witness, and not representing the regulator.
If I may finish. Yes. My Lord, the point I was trying to make, as my learned friend pointed out to you, yes. Correct. Now, absolutely. And my Lord, what I want to bring to the fore for the court to keep in mind is the National Infrastructure Fund will be implemented progressively, naturally. So the funds will not be kept in a current account. That impact translates to 72 million shillings every day. And what is the converse? The converse is,
again, I'm very sorry for this. Is that in an affidavit so that we can advise our minds on it?
The matters the court can take judicial notice.
Those are very technical matters as for counsels and the court to take judicial notice. Mr. Musangi has, and he should put that in an affidavit so that we can cross-examine it. We do not have... Yes, thank you, my Lord.
Yes. I'm not using personal information, I'm not using central bank information. I'm only... Absolutely. My Lord, nothing else. And my Lord, yes.
And Your Honor, we cannot allow false analogy in court. That's a false analogy.
My Lord, may I just be clear that I'm not talking about central bank. Anybody with money in Kenya knows what I'm saying. Anybody with money. It's not central bank. Let me move on, my lord, since they fear the impact from the side of the treasury. Let me talk about... And my lord... Yes. My lord, let's look at it the other way. As long as there is a status quo in order, the shares cannot be paid for. That is a fact. And if you extend a conservative an order today, or create one because it has expired, if you issue one, those shares cannot be paid for. My lord, if we hypothetically finish this case in July, and you issue a ruling telling the petitioners your case had no merit, the people of Kenya will receive the same 244 billion shillings, not a penny more. In which case, what would have happened is you would have granted a conservative order to a party that has not proven its case. And the impact of that order will not be remediable by any person sitting in this courtroom. Not one. And at the same time, my lord, and this is in the affidavit, the impact on our capital markets in terms of confidence will have been absolutely destructive. What's the remedy for that? My learned friends were pains to tell you about 40 million subscribers in Safaricom. My lord, government, National Treasury, and Parliament represent all of us. Not just 40 million, all of us. And the people of Kenya have had their say through the parliamentary process, through the public participation undertaken in that process, in compliance with the law. And ultimately, on 12th March, the sessional paper from the Parliamentary Select Committee was placed before the House with a motion for its approval after all these processes have been complied with. So we have constitutional compliance, statutory compliance, and procedural compliance. You have not been told one single breach of any of those processes to encourage you or convince you to issue a conservative order. In fact, in the main petition, the only pleading of a breach was that Parliament is not being involved in this process. And the facts belie that assertion, including the application by the petitioners for a certification, which then attached the motion under sessional paper number 3. So, my lords, if you consider the fact that the doctrine of separation of powers, the principles of public participation have brought in 60 million Kenyans into this process by their representatives or by the people who made direct submissions, what then are we stopping? And my lord, when you consider this court's broad remedial powers in closing, our courts have nullified presidential petitions. They have impugned many other processes, but they only do so when the party has proven the illegality, not before. So what is before you from the petitioners is is tantamount to a preemptive strike. Cause the damage and let the consequences lie where they may. My lords, my plea to this court is not to entertain a preemptive strike. Call everybody here. Let's hear them. And let's hear them soon, so they can actually tell you the facts. And it is clear from what I heard earlier from the petitioners that their house is not yet in order. They didn't know who they were suing. They didn't know what they wanted to claim. They now want to amend the petition. We don't know what the amendments are, and come before you with a cleaned up, polished case. If they are not ready with their own case, how can they in the same breath ask this court for conservative orders? And finally, my lords, even as you consider, and I will to come before you, the parties who want to be joined, I will state that before we are served with the application by the first party who applied, although we've seen it on the court portal and the second party in Andrew's client, they ought to show a distinct interest in the matter. And I say this because, my lords, you have been told there are 40 million M-Pesa subscribers. If the qualification to join this suit is simply having this code and an M-Pesa line to say I have an interest because I send M-Pesa once in a while, my lord, we could very easily have another application when we arrive at the hearing date from another subscriber, maybe 10, maybe 100, maybe 100,000. Are we going to let everybody in because they have an M-Pesa line? This case will never end. It will never end. So, my lords, on that basis, I urge you not to issue any form of conservative orders because nobody has laid any basis whatsoever for impugning this process in advance. Let's hear the case on this.
Yes, no, very briefly. Very well. Besides aligning yourself to what you understand the address the sovereignty of the nation. Now, I invite you to consider the provision 1.2, which specifically says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, that's Article 1.2. Now, Article 94. The legislative authority of the Article 94 note, the legislative authority of the Republic is derived from the people and at the national level is vested in and exercised by Parliament. Sovereignty. Number 2, the Parliament manifests the ability of the nation, represents the will of the people and exercises their sovereignty. The will of the people is not even established by 2 persons. It's an affidavit and an endorsement by the representatives of the people who are Parliament. Number 3, Article 95, the National Assembly represents the people of the constituencies and special interests in the National Assembly. Article 95.2, the National Assembly deliberates on and resolves issues of concern to the people. Now, one such issue is the self-election before you. Now, the issue of sovereignty is settled on both sides. Article 1, Article 94, and Article 95. But you have not been demonstrated one illegal action performed by the people, by the will of the president before. Not one minute. so that the status quo is to maintain the status of the will of the people as manifested and expressed by the people, not by two individuals. Not by two individuals. Number two, my lord. Status quo vis-a-vis the prayer source. My lord, I invite you to consider the final prayers of the petitioners, and amongst the very key mandatory prayers results, another directing, declaration that the sale or alienation of the government to pay the shares in Safaricom cannot be initiated or concluded without prior approval of Parliament and conclusive participation in the law. My lord, that has been done. That is being done. My lord, so that you are being asked in one way. We come before courts, say Parliament do the job, but on the same breath I say you stop Parliament from doing this work. And my lord, it's curious to know that Parliament is not part of this case. That's very intentional and calculated. Yes, to stop Parliament. No, my lord, that's the prayer. That's the prayer petition. That's the prayer petition. That's the status quo. Amongst the prayers. So that, my lord, they're asking you to stop what you did. And separation of powers and navigate to one another is something I will not be able. My lord, in exercising that parliamentary role, my lord, I invite you to consider an affidavit of the CS, my lord, and specifically paragraph 4. And my lord, what the petitioner sought, my lord, was addressed by this court, Justice Mugambi, on 23rd of March, and it specifically addressed worries and concerns. And my lord, the Cabinet Secretary, at paragraph 4 of the supplementary affidavit, confirmed that every worry that anyone may have thought has been addressed. My lord, in summary, number one was effective date. There shall be mandatory regulatory approval, which is ongoing. GOK shall obtain 40.2 billion. One is paid that to safeguard loss of public against loss of jobs for existing fact there shall be no opposition related redundancies in Safaricom PLC. My lord, that's one step further than that. So every concern that you would have been told to worry at the future at the end of the petition has not been addressed. All the worries that you address in the petition have been addressed. So what is the necessity for a status quo? My lord, the answer is absolutely none. Absolutely none. There's not a single illegality, there's not a single infraction by any institution required to perform its own approvals that has been cited to you. So that, my lord, the combination of this is that there is no basis for you to find that there is any order to even consider granting to interfere with the status quo of the sale of the shares. I pray that you consider and do not, because there are no orders, and it's important to read the orders of the Milimani, that you consider and feel that there is nothing to issue because the orders are already not issue any fresh status quo. Thank you.
I will be addressing briefly not on the issue of conservative orders, but the other oral application that we made. I asked for the 7 respondents, that's the Vodacom group.
Yes.
My lord, Vodacom group are done. My lord, Vodacom group, we have made an application to the Safaricom.
Yes.
I'm commenting on the oral applications before you. There were 2 oral applications. One was to add Vodafone Kenya Limited, and one was to amend the petition.
Yes.
So I'm addressing you on those 2 issues. And I'm reminding you to issue directions on our site out because that's what we're requiring. Because it was not mentioned by the petition. The application is dated February. I'll get the exact date for you. of February, 2026. 11. Yes, my lord. My lord, just remind you that application is currently unopposed.
Before I get to interfere, but that particular.
Mr. Lempa has been interfering with the
My lord, I want to correct that position. It is responded.
And I think it's extremely discourteous of Mr. Lempa to make a point of writing and interrupt every single council respondent.
We want order because we are a second order. So every time council is on its feet, if you want to object, right, stand with you. Okay, say you want to object, then you sit down, and the other council should take his or her seat. So that it doesn't proceed with a confrontation. That is an established rule in nations. All of us actually, we do that for all of us, right?
Yes, I will. Thank you very much for the guidance. We have responded. We have responded to that particular. We have responded to that particular application on the grounds of position and submission dated the same date, 14th day of April 2026, which is in the portal CPS, court tracking system, and it was served on her known email address. So the reason why I wrote that I'm very sorry is to prevent her from further misleading the law. Thank you. She has it because yes. When I did that particular yes.
Yes, thank you. So my point is that the Safaricom application is you can note that they have filed a round of opposition submissions.
So that's a reason.
So my lord, the point I was making is that the Safaricom application is intrinsically linked to the oral application to add Vodafone Kenya Limited as an 8th respondent. The first correction to make is that Vodafone Kenya Limited cannot be added as an 8th respondent because we currently have 10 respondents to these petitions. So the 8th respondent currently is the Capital Markets Authority, the 9th respondent is the Privatization Commission, and the 10th respondent is Vodafone Group PLC. So perhaps, and I don't think it, but I think Mr. Lempa simply just needs to remind himself when the 3 petitions were consolidated, we had a revised order of respondents, and we actually have more respondents. We don't have to fight for everything or impute bad faith to colleagues. Mr. Lempa. Vodafone PLC. No, my lord. These are separate legal entities. Vodafone Kenya Limited. The oral application to add it as an 8th respondent, it's never been a party to any of the 3 petitions before you. The strikeout application that we made was on the basis that our client Vodacom Group, based in South Africa, is not a contracting party. The actual purchaser of shares, my lord, is Vodafone Kenya Limited. So if you are allowing an oral application to add the correct purchaser, I am just saying that they must be looked at together. Because actually the oral application to add the correct purchaser is inherently accepting that our strike they found it.
So you are supporting the application to apply Vodafone and they remove your plan?
They are saying,
Yes.
give us direction so that they are acted together, not today orally, without an affidavit in support. Let them put in their evidence, give us direction, and we come back with to you, and everyone else can participate. So the first thing is we cannot deal with this orally.
Yes.
The second, or
what you are saying?
yes. So the second is to note that we already have 10 respondents to these petitions, my lord, so that we are careful when we are adding or removing to have the correct citation. So it's just something I point out so that we don't get ourselves further confused. Then the second oral application before you is to grant leave to amend the petition. We were told by senior counsel to correct a few issues. We do not have a formal application before this court that allows the parties to respond to it and to take instructions as to what are those issues and whether or not they should have been canvassed earlier, given that this petition, this specific one, E051, was filed in January, and we're now in April. But it is only to point out from the submissions made by the petitioner's counsel that these few issues do not appear either minor or non-material, and therefore they are deserving of a proper formal application and court scrutiny. And the reason I say this is because if the amendment of a petition is to add a party that is currently not before you, that is a material and substantive issue, number one. Number two, if it is to add, for example, as we have had, an issue to do with the IEBC and the election regulations, again, those cannot be classed as a few issues, because that is probably going to significantly change the nature of the issues before you today. So as we stand today, we came ready to meet the petitions that are before this court. There are 3 petitions, and we would urge the court not to disadvantage the respondents by allowing us to be ambushed by oral applications. And then there's a final point, my lord, I have to make, because I think I've been accused of bad faith, and my colleagues. My lord, I will have to respond. Because senior counsel said, and he repeated, that eventually when this matter is canvassed on the merits, there would be other and deeper arguments, including the sale of shares to a foreign entity. And then he emphasized it by saying, and I repeat, a foreign entity. But my lord, that is a gross misrepresentation of facts. Because the purchaser of the shares is Vodafone Kenya Limited. It is an existing shareholder, and it is a company incorporated in Kenya. And they will show you this because they want to file a CR12, my lord, in support of their application. So their CR12 will confirm what I'm saying. It is a Kenya company. So when senior counsel misrepresents and say this is the sale of shares to a foreign entity, and you have reminded us we are a court of order and a court of law, I must object strongly to this mischaracterization. I think it is meant to make you scared as Kenyans that you are losing something. I think I need to remind you that Vodafone Kenya Limited has been in your journey along the way, and is not new to Safaricom, and is within very much the jurisdiction of the Kenya court, and is subject to all Kenyan laws. So we would ask you for our directions. Thank you.
Yes, good afternoon once again. That's fine, my lord. Lordship, I represent Vodafone Group PLC. It's my recorded Lordship, ESMAIL. Your Lordship, I think it's important to have some purposes to point out, as Mrs. Odell has adverted, that when the petitions were consolidated by your brother Justice Mugabe, Your Lordship, there were 2 petitioners whom Mr. Lemba represents, and then there were 2 other petitions filed by unrepresented parties. And we took the liberty to consolidate them for all of them and put the respondents down. And my client, the Vodafone Group PLC, is the 10th respondent in the consolidated petitions. I will make 2 points, none of which touch on the arguments that have been made before Your Lordship and my ladies. And those 2 arguments as follows, my Lord. Firstly, the petitioner. Yeah, Your Lordship, I think it is important to point out that the petitioner who cited my client as a respondent is actually not interested in his petition at all. He is not present in court today, Your Lordship and my ladies. And for that purpose, Your Lordship and my ladies, they have not even responded to the submissions filed in support of our preliminary objection, which is dated the 4th day of February 2026. And I believe Your Lordship and my ladies have had an opportunity to look at the substance of that PO. It is simply seeking to strike out my client from these proceedings. Your Lordship and my ladies, I think my client's position is that we are not parties to the transaction and are not affected in any manner by the dispute between the parties. Your Lordship, to continue to occasion costs on my client to sit through these proceedings, while the petitioner first is not interested, and secondly, service was not effected as per the CCR, as well as the fact that there is no nexus between the allegations in the petition and my client. Your Lordship and my ladies are the principal reasons on which we ground our application to be struck out. So, Lordship, cognizant of the fact that the current contestation is on the issue of potentially conservative orders, as well as the other issues that have been brought before the court, we would be urging Your Lordship and my ladies to give us direction in respect of our appeal at the appropriate time, my Lord. Thank you.
Just one paragraph 45 of the ruling. That is Mr. Maro. Yes. Yes, paragraph 45 of the ruling. Paragraph 45 of the ruling dated March 2026. The court was just saying that this court may have to consider other aspects of preliminary objections that management has discussed. So we also received the issues of the key that we filed. I filed the AD filed a preliminary objection dated 17 March 2026. So we will also receive the actions on that. Thank you, Judge.
Concepts here is present. However, I heard this objecting to this joint mission. Yes. They say that they would object. Now, I need to bring to your attention Rule 7 of the Junior Rules gives you the liberty to enjoin us so I think we need to look at that once again. With respect, the owners and the drivers of the petition will not go under Rule 7 of the two rules. Go to 117, 2003. Yes, the joiner, I suppose, was made, position, my humble view, does not arise. The owners of the petition has been come over, and therefore, now looking at the discretion oriented, not even competition. And with all that policy, the Supreme Court has seen, used to partition be enjoyed because they made use of the rules made pursuant to the Constitution. Legal to 117, 2015, rule 7, you have unfair discretion. Having said that, it is my client's interest, therefore, to have the subject alive for adjudication with the status quo case.
I think we agree.
Yes, but I'm saying, I just want to bring a point of law. Because of now, if my client comes on board and the Morse has voted, this will be.
Consider these applications before we hear the petition.
Yes, what I'm saying.
I was going to come to those applications.
Yes.
So we were listening arguments in respect of status quo.
Yes.
And then we go back now to the specific applications of the directions.
Yes, I will agree. But I'm saying my client then, because we filed an application first, before we came in. And that application has been served for investigation to everybody. And I received communication from the minister that he was not objecting to giving file consent to the joint, which he did.
The petitioners are not objecting.
Yes, yes, yes.
We have no problem with that.
Yes.
Except now, other. Yes, I will be directions.
Yes, but I will just close by saying, yes, your worship, if you let us vote, in other words, you don't extend this out.
I'm going to
Yes. But that's not the time to go. I'm saying, no, now I interrupted you. Yes, but they are raising their voices. Because they are Colombians. They need to have the sound bites. They need to have the sound bites. They need to see resistance. That's why they with respect. Let me close by saying. I heard the is a limited window and so 7 days. So that everybody can come and answer the questions. Thank you.
Your Lordship, thank you for your great patience. That goes to show that this is a matter, as I started by saying, of grave national importance. I'd like to note 40 million subscribers to M-Pesa. We did make that claim that we had to represent them, but they're all interested. You see, there is a famous doctrine in law, res ipsa loquitur. Facts speak for themselves. It's a matter of brave national interest to all the Kenyans. My Lord, it has been argued by my learned friends that the court should respect the doctrine of separation of powers. Yes, there is no problem with it. But Parliament, in its wisdom, or lack of it, went against a court decision. It was issued by the learned brother on the 23rd of March. They went ahead on the 31st, you had it so eloquently placed before you. So that is a kind of respect for separation of powers that our Parliament has. Your Lordships, it's the same Parliament, I've been a member of Parliament for quite a while. There's some Articles 1 and 2 that sovereign power, the rights of the people, vested the people, which can be exercised either directly or indirectly through their elected representatives. When the elected representatives falter, as they did with the finance bill in 2024, then the citizens have a right to exercise it directly. Your Lordships, that's what the Gen Zs did. It is the same Parliament, Your Lordships, that went against the direct court ruling, just an example, that our policemen were not to be deployed to Haiti. We thank God they have all come back, minus 3 or 4, against an express order of the court. This Parliament and the executive.
Very respectfully point out,
It's a matter of law, my lord. It's really a matter of law. This is decisions of the courts, my lord, that have been.
He's trying to demonstrate.
I think you're going to be very brief for your comfort.
So allow me to give that one example.
Yes.
Don't give me
Okay.
Let
Let me then.
After that, let him revert back to being a lawyer.
Oh my, that is what I am. My lord. I'm here in that capacity. Because we're just trying to highlight how the executive and Parliament have failed to respect court decisions. And they do so with impunity, including the security laws which were ruled unconstitutional. So my lord and my ladies, the orders by Justice Mugambi are very clear. It is ordered under paragraph 2 that the balance of justice in favor of granting immediately an order that the status quo be maintained until the bench, which is this bench, is in place. I think we are in agreement that the onus is on your lordships to extend these orders, and that is our plea very strongly. My learned sister Abdallah is scared that I'm going to produce a CR12 to prove the point, my lord and my ladies, that Vodacom, South Africa, Vodafone, Netherlands, own 350 shares out of a total 400 shares in Safaricom. Is it Safaricom? Yeah, Vodafone. Vodacom Kenya Limited. 50 shares by the Netherlands Vodafone Group and 350 shares by Vodafone South Africa. Therefore, Vodacom Kenya Limited, your lordships, is a completely foreign-owned company. That is the truth of the matter. That is truly the matter. To allay the fears of the chairman of CBK, I wish these very reputable international organizations would stand guided by the fact that there is a contestation about the share of these shares. I personally, on behalf of the Kenyan people, because they can get a better deal, that's for sure. In business, you don't get what you negotiate, you don't get what you deserve, you get what you negotiate. It's a negotiation issue. So to say, no, I'm just responding to what your able chairman of CBK said. It was raised by from the bar, and I have the right to respond. because, my Lord, it was expressly raised. So it must be contradicted. Because all this in an effort to make believe there is not an issue of an urgent national importance before your lordships. This is where we see these conservatory borders. Well, even the very fact of the National Infrastructure Fund, maybe for information of the CDK, the CS body is before the IMF board, just for information. These are the issues that they are confronted with. And some of this infrastructure fund itself is subject to litigation. So my Lord and my ladies, nothing, we have shown the proof that Parliament acted in bad faith, which is one reason why, because they went against the ruling of Justice Mugambi. My friend Mugambi wanted to show one thing that goes to show this need to issue conservatory orders. Because if we don't, your lordships, we will come here and be engaged in some academic exercise when everything will have happened. We're all Kenyans. We love our country. And believe you me, we will prove, and I don't want to argue that point, because it is in our main petition, the undervaluation of the Safaricom shares. We will not allow this, your lordships, just to go unnoticed. Therefore, I strongly urge that when you retire, to consider your ruling. You'll act in a manner, as you all know you well, justly, and taking into account public interest, the immense public interest. Even taking 40 billion upfront, you want to forego your own profits, what are you telling the country? My friends, we want to have
Yes, my Lord, thank you very much. I have sat down here seeing the senior, Mr. John O'Hara, tell you that orders of Justice Mbochi were ousted or were saved by the court. That is not true. The truth of the fact is that application E14 of 2026 was heard before Justice John Mativo, Justice Ashoka, and Murungi. And they said that they cannot say declaratory orders or orders of certiorari as has been held in so many decisions of the court. So all the submissions, all the interactions made by Mr. John O'Hara should be expunged because he is representing an Attorney General contrary to orders of Justice Mbochi, which were not ousted. The case number is E014 of 2026. It's the application that was before the Court of Appeal. And if you look at the conclusion of that particular ruling by the three judges, it is clear that they declined to say the order, declaratory orders because they are negative in nature. That is very clear. It was done on the 10th day of March 2026. My Lord, on joinder, we have been told that Ilongo Nyakera and the governor, former governor of Nairobi, have no interest. My Lord, you cannot trash Article 22 on locus standi. And secondly, Ilongo Nyakera, for example, is the one who negotiated the IPO in 2007. And therefore, this is someone with a lot of, actually, Mr. Andrew Mukita Musani comes second to the information that he has about Safaricom, to Mr. Nyakera, to the intended interested party. So therefore, my Lord, these are not idlers. They are not mischief makers. They are people with substantive information that can assist this court arrive at a just and conclusive determination. You know, my learned colleague, whom we learn a lot from, Senior Kalonzo Ambassador, has told you that Parliament violated the doctrine of separation of powers. The Lord, if you look at Standing Order number 89, it bars Parliament from proceeding on matters that are pending in courts, so that it is sub judice. And the Attorney General is well represented in this matter and ought to have informed the speakers of the National Assembly. Information which we believe that the speakers would have ignored, that this matter is pending in court. Standing Order number, and I think Article 103 of the Constitution of Kenya is very clear that standing orders, my lord, are part of this Constitution. I think 103. Someone check for me. Standing Order 89 of the National Assembly, not of the Senate. Standing Order. Yes, thank you. Yes, my lord, I didn't you have been my chief master, but for some reason I never went to his chambers. Thank you very much. That is the standing order. It's very clear that the committee of the three arms of the government does not allow Mr. Masika Wetangula or Amason Jaffa King, the Speaker of the Senate, and the National Assembly Secretary, to admit matters that are pending before this court. And I'm reminded by my learned senior team that both are lawyers, actually senior counsels are told, and therefore they ought to have known that this matter is pending before Parliament, before this court, and it would be prejudicial for them to continue to deliberate on them. But my lord,
my good friend and judge, who will leave the Parliament because of that information, knew the significance of this matter. For some reason, he was an inquiry commission of both the National Assembly and the Senate on doing judicial proceedings. So there are two parties that is not present before this court.
Yes, my lord, I have said enough. Yes, before I was actually put down. The next point is on the affidavit of Mr. John Bandingo, the CS, which my learned colleagues glowingly talk about. My lord, if you look at that particular affidavit, it fails to annex the Hansard of that particular day, because even members like John Karoli Omondi, them people, opposed and actually brought to the attention of the speaker that whatever they were doing is not in the best interest of Kenya. My lord, then people super. And he's also a lawyer, my lord, I'm told. Yes, I'm not of the High Court. My lord, I wish to bring your attention to our further affidavit, dated the 15th day of April 2026, in reply to John Bandingo's further affidavit. We have annexed that particular Hansard. We have also annexed a 15-page memorandum dated the 26th day of January 2026 by the Law Society of Kenya. Law Society of Kenya was advising Parliament under Section 4, I think, of the Law Society Act. And my lord, they are very clear, and my learned colleague alluded to this, my learned senior, that even though they recognize the importance of having a free debt country, you do not sell the goose that lays golden eggs. That's the conclusion of the 15-page, the conclusion of that particular memorandum, 15-page, that is annexed to the affidavit of Mr. Ashoka, Tony, and his learned petitioner, his good petitioner, Professor Ogola. So therefore, it is not idle when we say that Parliament, National Assembly, is not acting in the best interest of, and that is well canvassed in that particular reply affidavit, which was signed yesterday, and annexures were done. What Mr. Marwas plan, and because I don't want to call him the region of that. Yes, I'm only trying, my Lord, with due respect, to debunk what that particular affidavit, which they have referred almost 10 times, by Mr. Ohanga, who is not even supposed to, because he does not represent, he is not supposed to represent the Attorney General, and Mr. Marwa. That particular affidavit has been responded to effectively by Mr. Ashoka, and you can see the motive of Mr. John Badimomo of material non-disclosure. So therefore, my Lord, the conservatory orders that we have sought, we urge this court to consider. You consider our submissions that are dated the 29th day of January 2029 that were also read by Justice Mugambi before he issued conservatory, or they don't want me to call them conservatory orders. Before status quo orders. And my Lord, I believe before this court rests its decision, we'll read the notes that were taken by Justice Mugambi, and all whatever they have said here was recorded, and those status quo orders were issued. And therefore, my ladies, my Lord, you have been told not to give a preemptive strike by the central bank chairman, board of directors. My Lord, what that amounts to is that you are being told don't issue that, so that we go and score on the other side, so that you come here 3 judges of probably around 70 years of experience from the time they were admitted to the bar to engage in an academic exercise. My Lord, tunaomba tafadhali. And I started by saying Safaricom PLC is as important to Kenyans as the Strait of Hormuz are important to the people of the Republic of Iran. Unless there is a question that you want me to clarify, I call upon Mr. Degwa to cross-pollinate on what I've said.
Your Lordship, I'll be very brief. I'll be very brief. Your Lordship, may I disabuse the notion that we are not making an application for an conservatory order. I refer you to the case Nairobi Civil Appeal 151, which is Invesco Insurance Company Limited. Yeah, I'm coming there. I'll show you how I'll link and annex this set of code to that order by this code. Yes, Your Honor. May I just read this judgment? Civil Appeal 151. Yes, I'm reading.
We have the right to call us. We have the opportunity
But
to refer to our authority.
Your Lordship.
This is never going to happen. As long as we keep that door open.
My Lord, we concede. We concede. And I want to say, from the basis forward. And JB 408 exceeds the status quo. Has been used. What is the status quo until? What is the status quo post? That I would have said. Because he wrote was to say that he also knows that.
Your Lordship,
we don't want to bring another authority which we need to ask for.
let me submit on it. The court will, if there will be need for them to reply, Your Lordship, then it is Maybe just need to Okay, I'm waiting.
I know the guy that is managing and friends here. You can see, please.
All right. I therefore submit that conservatory orders is a judicial remedy granted by a court by way of an undertaking that no action or any kind of preservation or that is needed to preserve the subject matter is actually an order of status quo for the preservation of the subject matter before the courts until the motion is heard or the petition is dismissed. On the separation of power, Your Lordship, I want to submit that that doctrine has since been penetrated by the enactment of Article 65 plus 2B, paragraph 2. That's no longer enjoying the constitutional virginity that it used to enjoy before. 165. Your Lordship. Clause 2, paragraph D, Roman 2. When we enacted the Constitution and gave this power the court to determine whether anything said to be done has been done in accordance with the Constitution, it gave you power to penetrate the acts and the actions and the functions of Parliament. It lost its constitutional virginity. Your Lordship, this doctrine is not as it was during the case of Madison. Granted the current enactment. On the question of the status of the status quo vis-a-vis our application for leave to amend, whether therefore we have disaffected the subject matter, the subject matter will continue to exist as it is until leave is granted and subsequently an amended petition is filed. The grant of leave does not mutilate the current subject matter before you that we are seeking to preserve. It does not even erode it whatsoever. It does not even cease to exist. And that is what we are seeking to hold, so that Your Lordship, as and when time comes and that perhaps amendments are brought before you, you will have what to advocate over. Remember, the rules of amendment, Your Lordship, is not to completely dissipate the original subject matter, it's to add to it. Your Lordship, finally, the doctrine of proportionality will only be applicable where the petition before you is primarily for the enforcement of the Bill of Rights. This petition has been commenced pursuant to two fundamental pillars of the Constitution. Pillar number 1, Article 22 of the Constitution, and pillar number 2, Your Lordship, Article 258 of the Constitution. Article 258 of the Constitution invites you to see whether the Constitution has been violated. Article 22 invites you to evaluate whether a bill, a right has been denied, threatened, or been violated, or infringed. On those two fundamental pillars, Your Lordship, and most importantly, the question of the violation of the Constitution, Article 3 enjoins you to uphold, protect, and respect this Constitution. Number 2, Article 10 again calls you to make sure that in whatever we do, Your Lordship, yes, Your Lordship. It was raised by my senior, Mr. Mr. Wagner. The point on proportionality. Yes, Your Lordship.
So this is about proportionality.
Yes, Your Lordship. And the obligation bestowed upon this court, the respect of the Constitution, the upholding of the Constitution. Yes. And you remember, Your Lordship, I submitted that this petition is premised on Article 258. If I was to harmonize those and read them purposively, Article 3 therefore calls you, while you are awaiting to see the alleged violation under Article 258, where the petitioner has lost their locus from, that you uphold the possession, that you preserve it. That's all the point I'm making. Your Lordship.
I was technically displaced, but just give me 2 minutes. 2 minutes.
Satisfied with the level
I will obey, but I will obey your order, Your Honor, but I'm begging for 2 minutes. I will strictly take 2 minutes. Your Honor, I'm just begging for 2 minutes. Just 2 minutes. I'm going to respond. I'm going to respond to what he said. That if you keep the status quo, they are going to suffer a certain amount. I just want to respond to that point. Your Honor, I'm just requesting for 2 minutes. I will have been done.
You will pay the 40. What do they have?
You should have told the leper what you wanted to say.
Your Honor, just help me to 2 minutes only. I'm begging, just like any other person.
Everybody will pay for 2 minutes.
I'll only use 2 minutes. Then give me 1 minute, Your Honor.
Just end this.
1 minute, please.
Let me be firm. Please take your seat.
I'll obey, but I'm just waiting for 1 minute.
Please obey. If you obey, sit down. Sit down. Please.
I'm going to obey, but I was waiting for 1 minute.
That is obedience.
Just obey and sit down. Now it's 2:40.
256. 256.
Yes, let me consult with my judge here. You denied me the chance. That's not fair.
I think the problem that's not fair.
So, Judge Amburele, are you still there? Judge Amburele? Oh, yes. So, it appears there are too many issues which are before us, and also a lot of assignments to be done, including giving directions in respect of the various applications pending before the court. We are aware that there are certain directions which were given initially regarding certain applications, especially the one dated 26 January 2026. Directions were given on that one, and also directions were given on the petition, replies and all submissions. So we wanted to suggest that if we can be able to find a pragmatic way of moving this petition forward, then that would be the best course to take. But if we have to go through the motions and spend a little bit of more time, for good reason, looking into each one of them specifically, then we are amenable to that. We have no problem. And we have noted that the arguments which have been put forward by the legal counsel, and I go back to what Senior Counsel Kalonzo said, are substantive arguments to be made in the application of Safaricom. So we have taken a view that we agree to come and hear that application for conservatory orders within 10 days. Take a date, which is appropriate. Those directions were given. Hear arguments. Then thereafter we give a substantive ruling on this. And we have also agreed as a bench of judges that as of now up to the 10th day, we are going to extend the status quo order. And we have noted the submissions which have been made regarding the date when the status quo order was made, and that was on the 3rd of March 2026. And other proceedings took place subsequently. We note that. So we would advise parties to desist from any form or attempt of disobedience of court orders. Because that is the only way we can have a healthy democracy. Democracy where separation of powers is right and with dignity and the kind of respect, not what was being described in the So I would urge that. And we want to be fair to all parties. That's the reason why we are ready to sacrifice our time despite our busy schedule to accommodate parties, but towards the major goal of resolving the substantive issues in the country. And then in the meantime, because I can see the application for joiner have been objected to, then once we hear the application for conservatory orders, we can also have a clear date to hear those other applications for joiner before now we hear the main petition, because that is where the parties will matter if they succeed to be joined in the proceedings. So that will be those will be the directions of the court. Let me record specifically here, and I'll also talk to the judge here to see whether there is something else which we have missed. We record the argument first.
Your Lordships, I take it that we, on behalf of petitioners, can go ahead and do the amendment.
Yeah.
amend the petition as we have actually.
I'll address that also.
Thank you.
So the amendment, before I recorded down what I just told you. The amendment, if it is in respect of bringing on board Vodafone, I heard you say that you don't have any objection, because that is the right part.
No, my lord, that what I said was you have to hear it together with strikeout.
We'll hear it together.
Because you are, otherwise you are advancing them ahead of our application.
All right. Then what we are going to agree is if they are cancelled, you say that within 7 days our applications to be filed.
Indeed.
So we shall ask you to file a formal application, 2 applications. In fact, one application for amendment and rejoinder, isn't it?
Yes.
These two can go together.
Yeah, my lord, will be also filing a substantive application and submission on the participation of Triple OK and Mr. Andrew Mukita Musangi as a public officer will be filing those.
You're very welcome to file them.
We will give a general order.
We have a right to
We will give a general order that if you have any application to file, you file it and you serve it within 7 days, because you are very serious. So that is a general order which gives room for all of you. Okay? So we will give that order. In the meantime, let me now record substantively what I have just told you.
Can I just clarify, that does not change the 10 days within which the application will be?
No, it doesn't change. That is quite separate. We shall keep that one separate. When the others come, we deal with them and they come depending on the nature. But where we can agree today, because directions on the hearing of the petition have already been given. We can even take a date for the hearing of the petition and then we work backwards.
Yes.
So I think that's the best way, isn't it?
Absolutely.
In the meantime, be thinking about a date around June. Around June for hearing of the petition.
For the petition itself?
Yes.
Yes, yes.
Then you work backwards. So be
Yeah,
thinking
yes.
about a date. For now. June. So be thinking about a date in June for hearing of the petition. Then we work backwards as we ensure that that date is kept as the matter of the petition.
Because right now I'm most interested in the application for conservatory.
No problem. 10 days. That has already been
Within 10
We
days.
are not changing it. Or do you want us to extend it?
No. 10 days. 10 days, my lord.
10 days is reasonable. That's why we consulted.
Yes, my lord.
We don't keep 14, but we said 14 is too much.
The conservatory orders, the other applications don't affect it.
No.
They can come after.
That is separate. We are putting it separate.
My lord, for clarification, I would like the applications for the participation of Triple OK and Mr. Mukite and Musangi be heard first, because there is no way we can allow them to present conservatory orders argument when they are not supposed to be in this matter.
We are not supposed to be in this matter. Parties entitled to representation
We
of
will-
his choice. That is a constitutional imperative.
Can you take your seat? Take your seat. Lepaka.
The part.
Lepaka, sorry, I'm calling it Lepaka. Lepaka. Do not, what do they say? Do not put the card before?
Yes.
Apply first. File your application within 7 days and we shall be talking.
Thank you.
Yes,
By the close of the day tomorrow, my lord, it will have been filed.
we want to finish instant. We have no problem. Okay, then we have the ruling.
Thank you.